Order!
European Union Withdrawal Bill.
We begin with new clause 16, with which it will be convenient to consider other new clauses and amendments as set out in the selection paper, and clause 5 and schedule 1 stand part. Mr. Chris Leslie to move new clause 16.
Of course, the bill that we're debating today, the EU Withdrawal Bill, was supposed to be merely a copy and paste piece of legislation. However, Mrs. Lang, you will notice, particularly in Schedule 1 of this bill, that there are a number of changes made that are not transposed. The government have specifically chosen not to bring across the Charter of Fundamental Rights.
The case for repealing it must be based on some harm that it's done. I have never heard anybody describe any harm that the Charter is supposed to have done to any public interest in this country. So presumably, like me, he awaits for some examples to justify the proposed change.
The point about Frankovich is, if you have a directive which we've accepted into substantive British law, you can't have a claim arising from that directive because we will have left the European Union, and that is simply just not fair.
Is his case that it should be transposed cut and paste, or that it should be adapted, particularly as Article 39 talks about the right to stand for the European Parliament, Article 44 talks about the right to petition the European Parliament, and Article 45 talks about freedom of movement, all of which, presumably, after we leave the European Union, would no longer be relevant.
Looking back over the history of the Charter, I have to say that some of the fears that were expressed, that it would be used for an expansionist purpose by the European Court of Justice in Luxembourg, I don't really think have proved to be correct. But in any event, we're leaving the jurisdiction of the CJEU, unless we have to stay in it for transitional purposes, when we're gone, it will be our own Supreme Court, in which I have enormous confidence, and our own national courts who would carry out that interpretation.
This House has not authorised the government to use Brexit as a vehicle to deplete the level of human rights in this country. Now, if the government wants to reduce rights and protections, they should say so, and we can debate it. What is not acceptable is to pretend that this bill provides for the transfer of rights and protections when it clearly does not.
I would just remind them that the current spokesperson on constitutional affairs for the Labour Party, the noble Lord Faulkner, told the other place on he is still a spokesman according to the Labour Party website, on the 14th of December 2005, he said, and I quote, "The Charter lays down existing rights. It is not a legally binding document." It later became clear, of course, Dame Rosie, that there was no opt-out. But it is right that we will be retaining the substantive rights and principles that the Charter merely sought to codify. And I will explain that in more detail shortly, but I hope on that basis I can urge the honourable member to withdraw the procedural amendment.
I wanted these words removed because I think they're completely unnecessary. As lawyers like to use that wonderful word, they are otios. So I was trying to help my honourable friend on this matter, not trying to create some devilish plot to scupper Brexit at all.
The other argument that has, of course, been made about the Charter is that, well, if the Charter does nothing wrong or it doesn't do anything by itself, what's the harm in keeping it? However, actually, my right honourable friend, the member for Rushcliffe, pointed out that the Charter only applies to member states when they're acting within the scope of EU law. Indeed, the Charter is a specific device intended to codify, not create, rights and apply them to EU member states and other EU institutions operating within the framework of EU law. It would be a curious, if not perverse, outcome to incorporate or implement that instrument directly into UK law at the very moment we cease to have the obligations as a member of the EU.
Why is the government going to such lengths to get rid of it as the one specific change in this bill? Presumably it's because it's got the word European and rights in it, and this was intended for a Daily Telegraph gesture to the hard right wing of my party.
Just last night, it was reported that a distinguished British jurist who'd been put up as a judge at the International Court of Justice has had to withdraw from the race because other countries in the UN are keener on somebody from another country. Now, even as a Scottish nationalist, I can see that that is a setback for the United Kingdom's world standing. And for so long as Scotland remains part of the United Kingdom, I would like the United Kingdom to be an outward-looking country. And indeed, even after Scotland leaves the UK, I would very much like the rest of the UK to continue to be an outward-looking country.
There's been a cosy consensus so far in this debate that everything about European human rights is wonderful, and we want to transfer it into our own law. Actually, many of us think that the advancement of European so-called human rights has been at the detriment of the rights of other people, particularly religious people, to find their own space, because European equality laws trump all other laws. So when we retain or regain parliamentary sovereignty in this House and through our democracy, we can start asserting the right to real human rights.
It really shows how good it is to have so many people on these benches who are lawyers, especially constitutional lawyers. And actually, most people are also very keen to be getting this bill right on a constitutional level. And the more we can debate it and thrash it around and get it sorted and reach compromises, sensible compromises, the better it will be for the bill, the better it will be for Parliament, and actually the better it will be for this whole Brexit business, because it'll stop some of this division and bring us all together.
The recent government announcement that we should have a bill to set out the terms of withdrawal and the implementation period will provide a good opportunity to readdress legal complexities and tweaks that may become necessary, for instance, through these proposals on human rights changing due to EU negotiations. However, as ever, the detail is where it counts, and I think this legislation is still something of an unpolished gem.
For me, as a non-legal expert, I believe it is about having a safeguard. We are keeping the law and the Charter because it is something that fills a gap that we would otherwise not have.
What it is a rights grab, and I think this must not be allowed to stand.
My constituents voted overwhelmingly, more than 75%, to remain in the EU. In all of the many conversations I have had with my constituents since the referendum, the word that they have used most often is values.
Is she seriously suggesting that the main reason that most of her 75% voted to remain was because of the Charter of Fundamental Rights?
The main reason why people are trying to get rid of it, actually, is it's extended the scope of European-sponsored human rights law in this country.
Isn't the answer to my right honourable and learned friend for Rushcliffe this? The rights may not be replicated in our existing law, but the protections are. The fact that a general statement of a right is not replicated verbatim in our law does not mean that those rights are not otherwise protected adequately and fully by the laws.
My position is very clear, that the Charter should not be incorporated into our law to go on evolving in this way according to the whims of unelected judges. Tonight we have the opportunity before us to reassert one final time what this House has been told for the best part of 18 years, that the rights under which we live should have their origin in this House and ultimately in the British people under whose authority we serve.
This is not about whether the Charter is in or whether it's out. It's not about being pro-rights or being anti-rights. For me, this is about whether a bill which is designed to provide legal certainty on Brexit Day will achieve that aim, or instead create what I think will be a feast for lawyers born out of legal uncertainty.
The ayes to the right, 295. The noes to the left, 314. The noes have it. The noes have it. Unlock.
Slim. The ayes to the right, 301. The noes to the left, 311.
The ayes to the right, 301. The noes to the left, 311. The noes have it. The noes have it. Unlock. The ayes to the right, 296. The noes to the left, 315. The noes have it. The noes have it. Unlock.
The ayes to the right, 295. The noes to the left, 315.
Shane.
Thank you. Thank you.
The ayes to the right, 295. The noes to the left, 315. The noes have it. The noes have it. Unlock.
The ayes to the right, 313. The noes to the left, 295.
I beg leave to report that the committee has made progress and asks leave to sit again.
Committee to sit again what day?
Tomorrow.
Tomorrow. Point of order, Leo Doherty.